Hey friends, criminal defense attorney Ryan Pacyga here, and I'm recapping what we saw in day 2 of the Chauvin trial regarding the alleged killing of George Floyd, as well as what to expect for this coming up day 3. So what you saw yesterday, if you were watching any of the jury selection, is really an in-depth look at how jury selection works. And there are a couple differences, but there are also many similarities. One, in this particular case, the defense and the prosecution had a little bit of an advanced view of each juror because there were written juror questionnaires that were sent out to prospective jurors before the trial started. And that does it to streamline the process and also to give the lawyers and the judge some quick identification of people who may need to be struck for cause, which means struck without burning up each side's strikes, okay? And indeed, we saw that yesterday. So these jurors receive these written questionnaires and they fill them out and they turn them back into the judge and lawyers, and the judge and lawyers look over them. And after that, they can identify sometimes, all right, here's somebody we might want to talk to early about some things, such as, do they have a health problem? Do they have a language barrier? Do they have such strong feelings about the case on one side or the other where they don't think they could be unbiased, or that they could set aside, as people say all the time, any feelings they have until they come to a decision at the end of the case. And sure enough, we saw that yesterday. So there are two ways that prospective jurors get unselected for the case. The first way is what's called for cause. That means that the judge agrees that there's nothing that can be done to change this person's views ahead of starting the trial, and they wouldn't be able to be an unbiased juror in the case. Okay, sometimes there's other reasons, like I said, health reasons. Maybe I just came off of a surgery. I can't sit still for 4 weeks and do this, or I've got some emergency thing at work and I'm not available. Things like that. If any of those things happen, the lawyers can agree that they should be struck for cause, and then usually the judge does, and that doesn't burn up one of either side's strikes. I'll talk about that in a minute. The other way it can happen, and we saw that happen a couple ways times yesterday. Another way that can happen, for example, though, is where one of the sides thinks there's reasons to strike a person for cause, but the other side disagrees with that. And that works both ways, but we saw that happen as well yesterday. For example, one of the people, the defense thought the person had said, I've got some previous judgments about this case that I'm bringing into it today. I can't promise you that I can be neutral. I'm kind of against one side or the other already, and I don't think I can back off that. Even if I would want to, I just don't think I could do it. Now, that's pretty clear that they should be struck for cause. But in that example that I'm using, the prosecutor then tried to do what's called rehabilitate that prospective juror by asking them questions to say, well, don't you think you could if you do this or that and all that sort of stuff? And listen, sometimes that can work, and sometimes it is a genuine misunderstanding of facts or what their duties are as a juror. But oftentimes what's going on is instead that even if the other side knows darn well that person shouldn't be seated as a juror, what they're trying to do is get them to do a 180 on their position so that the other side will have to burn up one of those precious peremptory strikes. So in that example, right, the defense had a person where they said, I don't think I can be fair. It was pretty clear that they were going to get struck, I think, by the judge for cause. But the prosecutor, rather than agreeing, okay, yeah, they've said they can't be fair, let's strike them for cause, the prosecutor tried their darndest to undo that, all right, and get that juror to do a 180. And here's what really happens behind the scenes about this. In this case, in this particular case, the defense gets 15 peremptory strikes, which means that's a limited number they get. Once they're out of them, they're stuck with any other jurors after that. So they can only strike 15 for peremptory cause. The prosecution gets 9. I'll talk about it in another video why those numbers aren't even. But at any rate, the prosecutor, if they know that they can get that juror to hem and haw a little bit, if you're a juror and you say to me, all right, I don't think I can be fair. I think Chauvin did this. I think he's responsible for it. I've seen the video. I just don't think I can be fair to him. I've really got a bad impression of him. And no matter what I hear in the trial, I think I'm going to find him guilty. You should be struck for cause, right? Okay, fine. So if the prosecutor can get you to say, yeah, but don't you think you could just set that aside? And even though you've already made up your mind and said you don't, can you just try really hard for us? And you say, yeah, I guess I could. All right, listen, if I'm the defense lawyer, I'm striking you. Now I'm going to have to use a peremptory if the judge won't strike you for cause. So the prosecutor, if you're thinking that this is really about trying to get a fair jury for both sides, let me stop you right there. Ideally, that sounds nice, okay? But what really happens is this. All of the marbles are on the table right now. Everybody's playing for keeps right now, okay? Because it's at trial and it's a serious case. Each side is trying to get the best jury that they can for their side. This isn't about, hey, I'll give you a fair one if you give me a fair one. That's not what it's about, all right? What it's really about is give me the best jurors that I can get that are going to adopt my theory of the case and be fair in my mind, what's fair for our side, okay? Because what you might think is fair for your side could be totally different than what I think is fair for my side. So each side wants their own types of jurors, not what's good for the middle, all right? That's what's really happening. And so we saw that happen as well, all right? So the other thing that can happen is that neither side can get someone struck for cause, or both sides agree, hey, this person's all right. We're not going to burn a strike on them. And that's where we got the 3 people that were seated yesterday. All right. You also had what's called a Batson challenge, where the prosecution was accusing the defense of burning strikes or using strikes to get rid of people of color on the jury. All right. Now, that's a really offensive thing. If anybody ever attacks a lawyer with that in a trial and says you're striking jurors based on race, that's offensive. All right. Lawyers get angry when we hear those sorts of allegations, typically. But at the heart of it, also, we do know sometimes that race indeed can be an issue in selecting juries. I wish it wasn't. The world wasn't that way, but let's be real about it. It can be an issue. And so I can't say whether the defense was striking some people based on race or not. I don't know what's in the defense lawyer's mind or not. What I can say is that the judge didn't think that's what was going on, and the defense was able to articulate legitimate reasons to survive that race, which is called the Batson challenge. All right. But the other thing the prosecution might have been doing is they might have known that they weren't really going to succeed on that Batson challenge, but instead what they were doing is they're saying, we're just letting you know we're firing some warning shots here, because we're going to get in the judge's mind. We're going to plant that seed in his mind, and we're going to let you know we're really watching out for that here, because we want a mixed jury as much as we can get. And so even if they knew they were going to lose that challenge, by sounding the alarm early on that, they're kind of saying, judge, watch this, and perhaps trying to get in the defense's head about worrying about whether they're going to look like that if they strike more potential jurors of color. So that's what's going on in the mind games that can happen during jury selection as well. All right. And finally, you've got the 3 sat. Now, what you can expect today, it's Wednesday, is more of what you saw yesterday. Some people struck for cause, perhaps, some disagreements about whether people should be struck for cause, and then lawyers using their peremptory challenge to get rid of some people who they just don't think are going to be good for their case, and then some more jurors sat again. That's what I expect to happen today. The only thing that could throw a wrench into all of that, and literally as the machinery is now spinning, these gears are spinning as we're picking up for the trial here and selecting this jury. If that Court of Appeals or Supreme Court does something where the prosecution has asked the Court of Appeals, hey, stop this right now. This is a jurisdiction issue. You can't let the judge keep making us pick a jury when we don't have this answer on the third degree murder charge. As these gears are thinking, that would fly down like a wrench and stop those gears right in their place. And then we'd have to see what's going to happen. None of that's really precedented in terms of the speed of these appeals and where they're at in the criminal process and happening like this. It just doesn't happen like that. So what's going to happen today is anybody's guess. If the Court of Appeals does something about it, that could stop everything or not. And maybe they won't do anything again. And if so, Judge Cahill will continue to have the lawyers selecting jurors. And in terms of one other thing that's happening is between 8 and 9 a.m. today, before the jurors get there, the judge is continuing to have the lawyers talk about what's called motions in limine, setting the ground rules for the trial. This piece of evidence can come in. This thing can't come in. This person can't say this. You guys can do this, but only to this limited factor and things like that. So remember, at the end of the day, in picking a jury, all right, you'd like to think that everybody's looking for a fair jury and that that's what's best. And yes, a fair jury to everybody ideally is what's best. All right. But we're talking about today, the scales of justice, if you can see that, all right? And what each side is trying to do is tilt those scales in their favor. And that's how jury selection really works. Hope that helps. Have a great day.